Welcome to the All In, All Out podcast. My name is Shannon Ross, founder and executive director of The Community. This podcast is focused on the goal of creating a justice system more worthy of that name, and why you, no matter who you are, should care. The name of the podcast refers to the fact that we must be all in and go all out to truly address the way justice is viewed and applied in America. Furthermore, the sense of separation the system imposes is an illusion. What happens to individuals on both sides of the fence is connected and tied to the same fate. How we treat incarcerated people reflects the state and direction of society. Those inside are all out, and those of us outside are all in. As for me, I am no more than a dreamer who knows there is a better way and is devoted to reaching out and holding on even when it is uncomfortable, because connections and empathy are the foundation of the types of strong, healthy communities that we all want. I spent 17 years in the Wisconsin prison system, where I obtained my bachelor's degree in business administration, had several articles published locally and nationally, co-created a mental health program that now exists in several facilities throughout the state, and founded The Community. Upon release at the end of 2020, I obtained my master's degree in sustainable peace building at the University of Wisconsin-Milwaukee, co-founded a successful multi-dimensional justice solutions firm called Paradigm Shift, became a first-time father, and I'm currently a consultant at Marquette University's higher education and prison program. But these achievements have occurred alongside numerous and constant failures. Therefore, I, and however, remain all in and all out. So today we have the wonderful Cecelia Klingele, and I want to apologize and thank you for a couple of things, for always taking time to, out of your insanely busy schedule in life, address my cockamamie questions that are always way more complicated than I try to make them around the justice system, as I try to understand the data and the claims that always come up, I think, from some of my colleagues and myself as well. And then taking the trip down here this morning for what is our last recorded episode of the podcast. It will not be the last one that we do that's released, but so that will be said in order that makes no sense when people hear what I just said, because it will not be the last one for the season. I also want to take time to thank Collectivo Coffee, who does not sponsor, but will in the future. Thank you, Collectivo, for your generous donation in the future. So I'm going to just start out with asking you about how you got into this work and kind of let you talk as you want to about the work you do now, because I don't like introducing people. It always makes me cringe when people introduce me, so I'll let you navigate whatever you want to in that regard.
Thanks so
that
much
question.
there, Shannon. Sure. Well, thanks for having me. It's a lovely drive from Madison to Milwaukee, especially on a pretty day. Happy to make it. So the work, and if by that you mean just really engaging in understanding the people in the criminal legal system, those who operate it, those who are affected directly by it, and how to make it better. I mean, that's how I kind of define the work that matters to me in this space. I came into it accidentally. I was, after I graduated from college, my husband and I wanted to volunteer. We had a little baby, so I couldn't do much outside the home. We became foster parents, and I was introduced to the family regulation system for the first time. It troubled me in a lot of ways because it seemed like the government was trying to do something good, and often it was causing as much harm as it was preventing. That made me curious about law and policy, and so I went to law school intending to do more of that work. But when I got there, not only did we not have a ton of offerings in that area at the law school, but my first class was in criminal law. And when I took that course, I realized that all of the questions that interested and troubled me about the criminal legal system were present, or about the family regulation system were present even more in the criminal system. And so we had a lot of offerings at the law school, working in criminal justice and with justice-affected people. And I was really fortunate to study under two wonderful mentors, Walter Dickey and Michael Smith, who helped me learn about the system and spend time in the Wisconsin state prisons. And after that, I kind of couldn't get enough of the questions that it raised and the opportunities for reform and change. And that has been the work that I have done for almost 2 decades now, took a brief break of sorts to do a little tour of the federal court system. I worked in the federal courts for several different judges right out of law school, and then came back to teach at the UW Law School, which has been a real privilege, and teach courses in criminal law, criminal procedure, sentencing, and things like that.
Okay. Thank you. Thank you for the work. I find being formerly incarcerated that I have an experiential lens. Sometimes that's zoomed in too much on a lot of these things. So there's the zoom out necessary need to solve any problem. And so when I try to zoom out at different times, what I find, the system is absurd in a variety of ways across the country. But what I also find is that it's very different in each state. Like you'll talk to I'll meet colleagues in different states, and they'll say something that they have going on in their state that's like revolutionary or different or better than what we have. And I'll say something like, dang, you got that? It's crazy. Then I'll talk about something we do, and they'll say, dang, you have that? We don't have that. So it's this back and forth of no one has a system that's necessarily better than other states in some cases. It's like different elements are more absurd or less absurd on this like that's my spectrum. I look at it across the country. Because we're fear-based. People are just fear-based for good and fabricated reasons a lot of times. And so in Wisconsin, one of the ones I think that stands out for our absurdity measure is truth in sentencing. And so can you talk about what truth in sentencing is and how it came to be in Wisconsin from what you know?
Yeah, sure, and interrupt at any point if you want to go in a different direction.
Okay.
So this phrase, truth in sentencing, a lot of people have heard it. The boring technical version of that is what we call determinate sentencing. And determinate sentencing is the opposite of indeterminate sentencing. So indeterminate sentencing is the sentencing system that was in place throughout all of the United States, really from early 20th century or even earlier until about the mid to late 1970s. Everybody used it. And the model was that a sentencing judge would, after conviction, say, okay, if you're going to be imprisoned, you're going to be imprisoned for not more than X years, let's say 10 years. And over time, the shorthand for that is just you're sentenced to 10 years, right, in the prison system. But everyone understood that actually under the indeterminate sentencing model, an executive branch controlled parole board would make a decision about the actual moment of release. It just couldn't be any longer than 10 years after the sentence was imposed. In some states, there was a minimum period of time you had to serve as well. That was pretty common. And so after the minimum period had been served, up until the maximum sentence imposed by the court, then a parole board would consider a variety of measures and decide when the person would be released. Then they would spend the difference between that moment of release and the maximum term, 10 years, right? So let's say you get out at 7 years, then you have 3 years of parole supervision in the community. And that's how the indeterminate sentencing system worked. Beginning in the 1970s, there was some widespread disillusion around this idea of indeterminate sentencing, and it came from the left and from the right, kind of from all over the place. And there were lots of different ways that people were feeling frustrated with this system. Some folks thought that it was just, a lot of folks thought it was just arbitrary. There wasn't a lot of guidance. There wasn't law, really, that parole boards had to follow for the most part. They were even constructed really differently. People were serving on parole boards who maybe didn't have a lot of qualifications. There was no accountability. The ways in which they decided whether people were rehabilitated were pretty arbitrary. There was concern that what they were really looking for was sort of class conformity more than actual rehabilitation, so that there was a lot of bias and disparity in the process, and concerns just about inequity generally and injustice. And so as people became more and more disenchanted with this idea of parole boards having expertise to decide when someone should get out, there were a number of legal movements that converged to try to eliminate or restrict parole boards and to give judges more control over that sentencing decision.
And was this state or national?
This was a national trend, right? The thing about and we'll see this later as we have our conversation, is, in the U.S., as you were saying, when you talk with your friends, right?
Yeah.
Like each state's a little bit different. Each county's a little bit different. That can be really great. We often refer in law to the laboratories of democracy, right? That states get to try stuff out, see if it works, hopefully throw away the bad stuff, pick up some of the good stuff.
Not learn from the states that did it right.
Right. The problem, of course, is we have very imperfect communication, different ways we measure success, right? And so it doesn't always play out so well. It's also really hard to generalize about this. And so there were some places that just retained indeterminate sentencing, never really changed. Some states completely abolished parole entirely and moved to an absolutely determinate sentencing model. Many states took an intermediate position where what they did was restrict the ability of individuals to have parole release, usually limiting it to the last 15 to 25% of the sentence, depending on the severity of the crime that had been committed. And then having judges make more firm pronouncements, right, about that amount of time to be served. And the reason it came to be called truth in sentencing was that there was sort of a rhetoric around the idea that when a judge says 10, it should mean 10, that's the truth, and that anything else was implicitly a lie. Now, in reality, everyone in the courtroom knew when a judge said 10 that it meant up to 10 years with parole release at X date, right? But you can see how, for the popular culture and for people who don't know law, there was an appeal. So the judge said 10, that should mean 10. The process of adopting determinate sentencing or truth in sentencing was sped up a bit by Congress. Now, Congress can't make state law, but there are different levers they can pull, to incentivize change. And in this case, it was what everyone needs, money for highways, right? Like we in Wisconsin are particularly sensitive to potholes, right? And how prevalent they are. So you got road money if you adopted more stringent sentencing practices.
I don't think I knew. Was it the VOIP? Was that something different?
I think so, but don't quote me on that.
Okay, so they didn't give the money for the system changes. They gave them money for highway infrastructure to make
more
interesting. I don't think I knew that part before.
Wisconsin, interestingly, wasn't one of the early adopters of truth in sentencing. So as I said, this started in like the 1970s, the really 80s, early 90s, right? Is when there's a lot of movement toward determinate sentencing across the United States. We were the last state to sort of jump on the truth in sentencing bandwagon, but we were all in when we did it. So we adopted the most stringent form of truth in sentencing. Many states, as I mentioned, still left a little bit of wiggle room. So for slight sentence reductions or reductions in the term of incarceration with good time credit or things of that nature, reducing that last 15% of the sentences for many individuals who've been sentenced. But in Wisconsin, we were like, nope. What the judge says is what goes. So if the judge says 10, it's 10, right? But we also recognize that there is some value, at least arguably some value, in having people leave prison with some period of community supervision. So there's transitional supervision, ideally support that goes along with that. And so we didn't want to get rid of the idea of community supervision entirely. So what we did was not reduce the sentence in order to provide a transitional period, but we left that custodial sentence in place and then added on, right? So we created what we call extended supervision. Functionally, it's the same as parole, except it doesn't reduce your term of custody, it extends it, right? And so now every sentence in Wisconsin from December 31st, 1999 onward, that is a sentence to the state prison system, is we call it bifurcated. It has two parts, right? So one part is the period of initial confinement. That's the custodial part of the sentence that you serve behind bars. And then there's the community portion, extended supervision.
Yeah.
So, a long answer.
Yes. And I think what's interesting is that there were these two follow-up amendments to that for TIS 2 and 3, I believe, where they allowed for these early release, the only early release opportunities that can be done in prison. Can you talk a bit about that, and how did the sentence adjustment part get included? Because I actually don't know myself when that was included.
Sure. So you're right. We had Truth in Sentencing, or TIS is the way it gets abbreviated in Wisconsin. The initial round of legislation that takes place, as I said, at the end of 1999. And then very quickly, it became clear that we were going to have it, that Truth in Sentencing was going to have a big impact on our prison populations, which were already high. There is something that we call the iron law of prison populations, which says that the only way to change a prison population is to change one of two variables, right? The number of people who come in and the amount of time they stay. What Truth in Sentencing did was it changed the amount of time people were staying, both on that period of initial confinement and then also as a result of revocation from these periods of extended supervision that were added on to the end of the sentence. So as we saw prison populations go up, and predictions were that they were going to continue to rise quite rapidly, the legislature did realize there needed to be some adjustments. Some of that was anticipated from the very beginning, but there wasn't consensus enough to reach the final goal in one round of legislation. So what we saw were a few small adjustments, as you mentioned, to the ability of individuals convicted of some kinds of offenses, usually lower level felony offenses, to petition the sentencing court. Again, everything goes to the sentencing court under this model for earlier release if certain conditions are met, primarily completion of programs or other things of that nature. And what we see still is that means statute is in place that allows people, as they near the very end of their sentence, to petition the court, usually without an attorney, because it comes up quite rapidly for a lot of individuals, that last portion of the sentence, and to ask for earlier release. In practice, we see really varied results around the state. Some judges grant those fairly routinely. Many others deny them out of hand without a hearing. And then there's a range in between as well.
Yeah. And I know a couple of things stand out for me. One is we presented to the annual judges conference about, I think, 2 years ago now, somewhere around then. And since then, Milwaukee was, I believe, the worst in the state, but they're the worst. They're one of the worst. It was 9%, I think, is what they had.
They
did
not have
approving.
A very high rate of granting sentence adjustments. Yes.
And it was. I was shocked at how low, since we have the most people going to the prison system from Milwaukee. Maybe the volume, I don't know what it would have been, but since then, I know two people, friends of mine, that got out that were approved in Milwaukee, and I was asking myself that maybe something from what we presented have anything to do with both of those cases. Both of them were different. Like, they both had done a fair amount of things since they were in. But and Raina actually helped John, my friend, get out in one of those. And so I always wonder, like, the outcome of that. And so maybe that was something. And then also for myself, when I talk to people, especially in different states or even here, folks that don't know we have this truth in sentencing model, even now, folks are always like, oh, there's parole, right? Like 20 years later, 24 years later, people don't realize we don't have parole anymore if you've been sentenced after 2020 or 22,000. And yeah, people are shocked when they'll say, like, no, I did all of my time. I had no opportunity to get out early. But I also knew that they have a built-in policy where if you do anything wrong, you can get like 10 more days added to your bifurcated portion, right? They can take your out time and they can add it to your custodial portion of your sentence. But they don't do it unless it's something egregious, because they know, as you said, this is going to get out of hand if we actually start giving people 10 extra days for every one of these piddly little infractions. Because I had 32 tickets when I was inside. I was talked to and had warnings countless times, right? So I would have probably done several more years of my time if I had gotten all these things. So I just knew that I wasn't going to get any more time or any less. And what that did for me, when I look at my friend Adam, who had parole, and he had the eggshell experience of like every single thing would mean more time, right? Because parole would look at it and judge it differently. He's very, very cautious, very thoughtful of everything. He's in his head about a lot of things, whereas for me, some of this is very different in the way we are as personalities. But at the same time, the way I did my time, I was able for 17 years to say, I'm going to take whatever risks I feel I need to for my benefit going forward when I get out. Like, I had a cell phone at one point. I made countless throughway phone calls, which were like a ticket. I got one ticket out of the hundreds I probably made when I was inside for calling my academic advisor. That's the one I got a ticket for too, was calling my academic advisor. So all these things I did for my benefit that have shown to be very effective things that I now take advantage of post-release. Whereas Adam couldn't do any of that because any little thing would be maybe another month, maybe another year in prison. So I find that there's this element that people don't realize when they made the law, and even right now in operating it, how it has an impact on how people then, come out now. And I think we'll talk a bit about that later, maybe. So it's just really interesting. So with that, kind of segueing to another part of some of this simplified cliche data that you so generously endure with my questions when I ask you is we have this moniker as having the worst. I think I've heard 6 worst before, but one of the worst, whatever it is, the post-custodial portions of the sentence in the entire country. Can you talk a bit to like what the data is saying there and why it's difficult to have that type of a statement made?
Yeah, sure. And thanks for putting up with all my boring academic explanations.
I love it.
Right, which I know get really, really tedious. But I do think it's important for people to understand sort of why it is that folks like me are often seem extremely cautious when we make comparisons between states. So as you alluded to, you and I have talked a lot about things that you'll read in the press or people will be quoted as saying, for example, you just said Wisconsin has the 6th worst, 3rd worst, whatever, lengths of community supervision in the country. Well, my reaction always is like, well, what do you mean by worst? And you would think that would be an easy question, but it's not. And here's a teeny bit of why that is so. First of all, it's a lot harder than you'd think to take all of those 50 states we talked about, and then if we really wanted to complicate it, right, we could throw in all the territorial governments, we could throw in tribal courts, we could throw in military courts, right? All of these different entities that have sentencing power in the U.S. And generalize even about one of them. So I'm going to pick on Ohio for a second, because although I haven't worked with Ohio law for a while, I still remember how confusing it was when I did.
We're not anti-Ohio.
No, Ohio's great. My father grew up
if you're
in
a listener,
Ohio. It's all good. But I, a number of years back, was doing some observations of community supervision in Ohio and talking with various system actors there. And I was just focused at that point on probation, so non-custodial sentencing before someone goes to jail or prison. And I was trying to get my head around, okay, how does probation work in Ohio? And it quickly became apparent from the different language people were using, there were 3 different kinds of probation. And there were some people who were on like all of them at once, reporting to like different entities based on what court had sentenced them and what the like severity of their sentence was. I never, quite frankly, mastered that. Like I did not understand it. But even in that one jurisdiction, to generalize about probation is to risk missing some of the nuance. And that's going to be true in almost every state. That even in states, for example, that have functioning parole boards, many times not all folks who've been sentenced are parole eligible. Only people who, let's say, have a class G or lower felony offense, or only people who are sentenced within a certain time range are parole eligible, and other folks might not be. So you can indeterminate sentencing and determinate sentencing operating all at the same time, and people with different kinds of legal structures that are governing them reporting to different supervising agents and agencies. It gets really complicated really fast then to try to make a generalization. When it comes to sentence lengths or supervision lengths, so let's take extended supervision in Wisconsin. I can tell you that we have a long period of authorized supervision, and we can point to models of states that don't allow that kind of duration of supervision. So in Wisconsin, we have several sentencing statutes that very specifically say the minimum period of extended supervision and the maximum period of extended supervision that are available for any particular kind of felony offense, right, for which someone would go to prison. At the same time, there are circumstances in which, right, we still do have individuals. It's a vanishing number, but it's still a number of people who were sentenced before 2000, right, who are still parole eligible in the state of Wisconsin.
Something
as
under
well.
1,500, and I think they're at
Right.
now.
So it had, because, right, we're now almost a quarter century past that, it was people serving very long sentences. So there are fewer of them in the state prison system, but we still have parole and people who are on parole, including in some cases, people who are on lifelong parole supervision. That's not the norm, of course. And most people serving terms of extended supervision, we also have to compare when we talk about, for example, worst. Are we talking about worst in terms of the amount of time they could have been sentenced or the amount of time they were sentenced to extended supervision? So typically, when we're trying to gauge sort of like the legal power courts have, we look at maximum sentence lengths. And so you can compare maximum sentence lengths across the country. In reality, judges most of the time don't give people maximum sentences. They give sentences well below the maximum sentence. So then your actual sentence lengths can be significantly different from maximum penalties. We could try to compare those, though it's harder because then you have to figure out what's happening on the ground in all of the different states. There are a number of jurisdictions that limit periods of supervision after prison to, let's say, 3 to 10 years. That is there are a number of large jurisdictions that do that, especially for the bulk of felony offenses. There usually are some outlier exceptions for homicide-related offenses and other very, very serious crimes. But if we look at sort of your standard range of felony offenses, many states and jurisdictions that we don't consider soft on crime, like the feds, the federal system, or Texas, right? They limit periods of supervision. And there are good reasons for doing that, including the fact that much of the time, if someone is going to be on supervision and is going to commit a serious offense, that's going to happen pretty quickly following release. Within those first few years following release, that's where most of the supervision happens because it's where most of the transition is happening for individuals. The further in time you get away from the original sentence, just the less justification there is often for sort of closely watching someone. And many times agents have told me their experience, as well as the experience of those being supervised, is that supervision starts to get in the way of your ability to do your job and maybe travel for work or get a promotion, things like that. That said, when we have to also be careful about comparing apples to oranges. So extended supervision in a determinate sentencing system like ours, right, the lengths seem pretty long because they're added on to that period in prison already. Remember, though, that when people have parole-eligible sentences, the amount of time from release to the sentence they were originally given, that's all a period of supervision. And that, in some states, can be a long period of time. So people can be on parole for a long time in many states if they had a high sentence and were released fairly early in the sentence. So it's hard to compare, is the short version, but you wouldn't have had a professor on if you wanted the short version.
So what would be someone trying to talk to an audience and make a very quick statement about how our extended, if we just focus on the extended supervision part, right? Because parole is not as, and I'll talk to two things that are interesting there in a second, but parole notwithstanding, if someone were trying to make a statement to an audience that doesn't know about the severity, the stringency of our extended supervision time, what would be a safe thing they could say about that? Because it seems like ranking it is not the best way to go, but maybe just saying we have an awful amount of time people get post-incarceration.
Yeah, I think it's important to look at the amount of time that people are spending supervised after committing an offense. Now, in order for that to have an impact, first your audience has to understand what supervision is and why it actually imposes burdens on people. That it's not just a helpful way to get a voucher for services, which is what some people think supervision is. Instead, it comes with a lot of restrictions. Some of those restrictions might make sense, some of them might be even intuitive, but a lot aren't. And so I think there's a lot of that sort of foundation building work that has to happen so that people understand that supervision isn't nothing, right? It's not, people often talk about slaps on the wrist or, giving you helpful guideposts. I think people need to understand the spaces and ways in which it can interfere with people's ability to build lives, to build families, and to secure meaningful employment. Once you have that, then you can say, well, look at how long this goes on. And then think about that in really human terms, because I think often when we think about crime, there's like some little weird space in our brain that we go into that is divorced from everything we know about people and the way people act and grow and flourish, right? So when you and I are both parents, so we know, right, there are things that you do with kids for a while when they're small or when they're in transitional life stages, and you're not there yet, but fun to come, let me tell you, spoiler alert. Right, when they're teens, they're going to need something different than when they're young adults. And young adults turn into older adults, right, who need different things. And somehow we know this when we're working with our kids, when we're working with our friends, when we're employers and when we're teachers.
With ourselves.
Yeah, we know, right? We need different things at different ages, and that we change and we don't stop changing.
Yeah.
We keep, ideally, maturing, learning, growing, right? And we need more structures when we are in places of greater vulnerability, and we need less when we're in places of greater strength. And that giving people too much constriction when they're growing actually impedes growth. But we act like that's not a truth of human nature when it comes to criminal justice. So the idea that someone who committed an infraction, let's say in his early 20s, which is a time during which sociologically we know people are still quite vulnerable to acting in deviant ways. There's this time in between mid-adolescence and late teens, early 20s, where it's actually statistically normative, right? It's more likely than not that young men are going to do something that falls outside the law. Now, maybe
so we're dumb, is what Professor O'Reilly was trying to say.
You're developing, right? Your intellectual capacity, your moral capacity, all these things are developing. And we don't get it right. Now, we all know we never get these things perfectly right. We come into greater compliance with the law, hopefully. But we still are growing as people and in our moral decision-making capacity, right? Well into old age, hopefully. So we have these times when it's normal. Let's say someone really does something harmful, is punished, is imprisoned, is released to the community. Okay, by this point, we're looking at somebody in mid to late 20s. Once you're in that point, you're past that high arc, the age crime curve, we call it, right? So we know that statistically you're less likely to commit offenses simply because you're aging and maturing, making better decisions, and hopefully establishing connections that make it less likely that you're going to offend. When I talk with my students about the purposes of punishment that the law recognizes, right? They include just straight up punishment, rehabilitating people, deterring people from committing more offenses, and incapacitating them, right? We often think of prison as like the prototypical incapacitator, right? You can't do anything because you're locked in this space. But I also point to them that they can't do almost anything when they're sitting in my classroom either.
Right.
I'm incapacitating them for the hour or 2 hours that they are stuck with me. Maybe they're being deviant on their computers, but hopefully not. Right? And I have them under control. We just don't think about it that way. Well, kids incapacitate you pretty well too if you're doing parenting right? And there are lots of things in our natural lives, our obligations to elderly grandparents, our commitments to community organizations, going to work every day. That helps us follow the law by giving us meaning and patterns and keeping us from getting into trouble. Right? If we're doing things in people's lives that call them away from those natural sources of incapacitation, no, you can't hold that job because you have to go to meet your agent, right, in the middle of the day across town. In a way that's going to mean you miss a whole day of work, right? Then we're weakening the bonds that help people mature and grow. And I think we want to focus on the fact that people may need artificial structures for a little bit when they come out of prison. That may make some sense as we're transitioning and getting them connected to...
Especially higher needs folks.
Totally. Yeah, right. I don't want to imply everybody needs that, but I think some folks may. But that has to fade out. That's part of the normal kind of developmental pattern. To say that 10 years after someone has served time, they're still being supervised, if anything, to me, suggests something about the system has failed. Right? We should be working our way out of a job. And people should be given opportunities to flourish and to reintegrate, ideally. Yeah. And if people are not in a space where they're able to behave in ways that are safe, then presumably they will have failed on supervision and been charged with a new crime or whatever. The system will have acted, right? But the idea that we're just going to go on with perpetual babysitting effectively seems really problematic to me, just from like a normal human developmental perspective.
Yeah. No, I like that perpetual babysitting. Exactly what a lot of it is. And a lot of the agents feel that way as well. Because they feel like they're trapped in a situation where they have to keep watching somebody that they're like, I have clients that need my attention and I already have a heavy caseload. Like, why are some of these people even on my caseload still?
One of the most memorable conversations I was ever part of was about 10 years ago. I was at a conference and I was sitting around a table and there were 3 or 4 current or former heads of major U.S. probation agencies, along with other folks who were judges or academics involved in sentencing and corrections. And one of the agency heads looked at his peers, right, who had run agencies and said, do any of you think that if we halved supervision sentences today, we would have any major issue with public safety? And all of them said no.
Yeah.
Now, I suppose there's probably a self-selected group that's at the conference I was attending. But even so, these were guys who knew what they were talking about, who worked in major metropolitan agencies, right? They understood real safety risks, they understood political accountability, and they didn't understand why their field was developing in the way it was, which is why I think you see engagement from a lot of professionals in the field of community supervision on the front end of some of the efforts to rethink the way that probation and parole and extended supervision function.
Yeah. And to add to the absurdity, but wait, there's more.
Do.
In Wisconsin, there is these 2 additional elements of one. If I take the example of me and Adam again, right? Adam is right now, I feel safe saying this because it's likely going to happen, and if it doesn't, it's still possible. There's a very good chance he'll be off of paper sometime very soon. He's already far down the path of that happening, and he has life on parole, right? So of the 2 of us, I have a 15-year post-incarceration sentence. He has life. He has an apparatus to get off early and likely will 5 years after getting out, whereas I have no opportunity. And that's not a bitterness towards Adam. Adam should not be on. I'm incredibly happy for him. But it's like there are these 2 different systems where TIS also allows no opportunity for a person that's on TIS for the system to let them off, even if they want to. Even if everyone in the system wanted to say, Shannon, you're off of paper early, there's no way to do that unless I legally get resentenced under a modification, which is, I don't have the apparatus.
But right.
Yeah. And so, and then so those are the 2. Oh, and one more thing. If under Truth in Sentencing, the way it's set up, I think we make a bigger deal about this than we should because it really doesn't happen, but it's on the books possible. If I get to the last day of my sentence and an allegation is made, I'm 14 years and 364 days into my sentence, an allegation's made, no actual due process happens, I can be sent back to redo my time and come back out and redo all 15 years again. And so that is also still there on the table under TIS. And so those are 2 parts that even make it more absurd that we have this process in place. So I don't know if there's anything there that you wanted to add to those 2 elements, or maybe I'm wrong about some of that.
Well, I think you were certainly right in the observation that people who did the same thing in the same state, but at different times, have really, really different legal structures to which they're subject, right? And that can feel super arbitrary. Just like folks who were given parole-eligible sentences at the same time that Truth in Sentencing was coming on board, saw the parole board become more cautious about releasing them than had been the case 10 years before, right? So there are all of these factors, legal factors, discretionary decision-making factors that overlay and lead people often to feel that there is inequity in the system. And I think in criminal law, one of the hardest challenges is this tension between discretion and law, like how much we want the law to mandate that everyone have the same results, and how much we want to leave space so that judges can make individualized decisions when it feels right, knowing that that increases inequities in a lot of ways, right? So it's a perpetual tension in law that's hard to resolve. When it comes to your observation about revocation, I think that highlights an area of the law that I care a lot about. I don't know that it gets a lot of attention, but it really matters, I think. And that is this idea of what we often call street time, or we call it the vesting of time. These are technical terms you'll hear. So there's a question when a person's serving a term of community supervision of how the system credits the restriction of liberty that comes along with that, right? So as we mentioned earlier, right, if you're on extended supervision, you're going to be subjected to a number of different restrictions. In some cases, that's pretty onerous, and in some cases, it's less so. But regardless, you're not at liberty to just do what you want, when you want, how you want.
Yeah.
So the thing about street time that is important is that it allows an individual to get credit, recognition from the system for time that he or she has spent having to follow rules that aren't of their own making.
Yeah.
There's too often, I think, an impulse, and this is what happened with truth in sentencing, was a sense that, like, well, people are supposed to follow the rules. That's the condition of not being in prison. You get to be in the community if you follow the rules. So that's just a basic expectation. And if you don't follow the rules, then we can return you to prison for the full length of time, up to the full length of time that you were supposed to be in the community complying because you weren't complying. That is, I think, too simple an answer because, as you point out, people can, in fact, be in substantial compliance with the terms of their supervision for a long period of time, and then something can go wrong. And when something goes wrong, under our old system, they would still get credit for the time they spent in compliance. So let's say you had 5 years of supervision, you did okay for 2. At the end of year 2, you get revoked. You could go back to prison under that scheme for 3. In Wisconsin, as you noted, when we adopted truth in sentencing, we also got rid of the vesting of street time. And so now, if at year 2, something goes wrong, you could theoretically go back for the full 5-year period, right, with no credit. Usually it's not 5 years. It would be some fraction of that, right? People would go back. Let's say they go back for a year. They come out. There would be 4 years of supervision left, right? And although, again, typically people succeed after revocation, it is possible to do what my mentor used to call life on the installment plan, right? Where you start to get your feet under you, something goes wrong, you go back, and it seems to never end. The danger with this, I think, is particularly when people have been originally sentenced for crimes that, may have merited prison, but were fairly minor in the great scheme of things. Yeah. And all of a sudden, we see decades of a person, or a decade or more of a person's life, sort of entangled in the system, where perhaps that's not necessary, and we could have recognized success during the periods of success they had in the community. It's a complicated topic, I realize. There are lots of reasons why sometimes the system takes a while to respond when someone isn't in compliance. But it seems to me that we should at least be able to come up with a legal structure that recognizes some level of credit, even if it's half. You get credit for half the time you're in compliance. Something that recognizes that people aren't at full liberty in the community. Yeah. And we don't do that, and it feels really unfair to people. And I think that we need to pay more attention to any law that is experienced as unjust, because when people don't feel fairly treated, they are less likely to see the system as legitimate, and they're less likely actually to comply with the law going forward. Tom Tyler's work on this is really I think, so important. We call this area of law procedural justice, the sense that being treated fairly and perceived as having been treated fairly is really essential to people internalizing the value of the law in the legal system.
Going from that, I think it segues into, can you just talk a bit about crimeless revocation? And I think to more specifically, what is it? But there is this focus from a lot of the work that happens around reform on the line that most people that are in prison are in there because of crimeless revocation. You'll hear that kind of line a lot. And I don't know if that's true or not. Even if it is true, I think the thing that is really interesting to me is talking to systems folks who are not, somebody might hear this and say, yeah, well, of course the systems folks are going to say this. There are a lot of people that work in the system that are not with the system, right? Like, they're very much trying to change things. They want it to be very, very different. I can even speak about one prominent judge who recently retired who's even said the whole thing should be dismantled. It's like, so there's a lot of systems folk that are like sick of this. But what I've gotten, what's been made aware to me is that people that go back for crimeless revocations, a large number of them would have gone back for a crime. The system is just saying it's easier to take this path and it's better for you as well if we give you a crimeless revocation return instead of a new charge. And so just kind of get your thoughts on, like, what is crimeless revocation and what do you think about that component, which makes it a lot more tricky than the things we say of blaming that for the fueling the system.
Yeah. And I'm just going to start with a disclaimer that, like, my position on this is probably not, like, the position a lot of community supervision reformers take. I hope I don't. I appreciate the work that's being done in this area, and I understand why people choose the language they do, because even just in this conversation, right, we've gone back and forth a couple of times on how it's hard for people to understand sometimes or wrap their heads around too much nuance, and so sometimes you just need a clear message. I get that. At the same time, I really react against the term crimeless revocation, and someday maybe I'll finish an article I've been working on for way too long that actually takes it on. But crimeless revocation, so first just to define our terms, is like the savvier version of the old phrase technical revocation, both of which refer to situations where a person is revoked from community supervision and sent to prison because he or she has not followed a rule of supervision that in and of itself doesn't constitute a crime. Right? So if I committed the same behavior, I didn't show up for a meeting, or I didn't report that I took out a new credit card, right? Those aren't crimes, and so I couldn't be punished for them, certainly not with imprisonment. But if a person on supervision violates those kinds of technical or crimeless rules, theoretically, any violation of a condition of supervision can justify revocation of community supervision and return to prison. Quick point, this isn't the 1980s or 90s where, a missed visit or two actually might have put you at risk of some kind of custody. Even then, I think usually just missing a meeting wasn't going to do it.
Yeah, we use a lot of those type of examples, and I'm like, I don't know one person that's ever gone back for something like that.
Yeah,
like,
right?
It's possible, but that's not really happening.
It's important because I think people who want to improve community supervision undercut their own legitimacy when they choose examples that are not real, when they're not honest.
We already have a great argument. Why
Exactly,
use things that are just
there are good examples of things that aren't just.
Yeah.
And I think it's important to stay away from the low-hanging fruit that seems very hyperbolic but isn't grounded in reality. In any event, let's take one that is still a stereotype, but is at least a cleaner example. If an individual who's on supervision for a sexual offense and is not allowed to be in the vicinity of a children's school is found on a playground at a school, it is not a crime to be on a playground at a school. But for that person, it would be a violation of the rules of supervision. We can see pretty easily, I think, a connection, at least possibly a connection between that rule and public safety. That would be a technical violation, right? But is one that might result in some kind of a sanction for a person. So that would be, if you get revoked for something of that nature, we would call it, or the term being used now is crimeless revocation. That's contrasted to situations where someone is revoked because they engage in behavior that is then charged as a new crime. Sometimes we get a revocation after the person has been convicted of the crime. Sometimes it's the filing of the charge that initiates the revocation alone. Different systems operate in different ways, but in any case, it's tied to an actual new criminal case.
Yeah, sometimes revocations before the case, I think, as well.
Is.
The people that have been
Yes.
that are in prison that were revoked for the thing they haven't even been convicted of in some cases.
That's right, because we have statutes of limitations that allow for district attorneys to charge for many years after an offense is committed. Different counties are sort of operating more quickly or less quickly, depending. And so, yes, these two systems are separate. The other thing important to remember here procedurally is that when a person is charged with a crime, the prosecution has the burden of proving beyond a reasonable doubt that the person committed the offense. In a revocation proceeding, the agent only has to show by a preponderance of the evidence to an administrative law judge. In Wisconsin, that's our version. There are lots of different ways to handle revocations. In Wisconsin, we use what we call ALJs, administrative law judges. But you only have to prove that more likely than not it happened. Just a much lower burden of proof versus the new crime situation. Some of what you're saying, so a lot of people have said, wait a minute, this is ridiculous that we're sending people to prison for things that aren't even crimes. We can maybe come up with a sanctioning system, but it shouldn't be revocation and return to prison. Some states, I think of Washington State in particular, have experimented with this, with short jail sanctions for crimeless revocations rather than a return to prison. There are lots of different ways that you can handle these situations. And in general, when you're talking about a low-level offense, first of all, I think most good agents are already handling those without a revocation. Right? They're finding other ways to manage the behavior, to think about its causes. Sometimes you need to actually just intervene and work with people to figure out why are you missing your meeting or what is going on that you need support on. If you're having, let's say you have fail a drug test, do we need to get you some more intensive treatment? All of these kinds of questions that would help the person succeed and not get revoked, I think are happening most of the time. In situations where there is a true crimeless revocation proceeding, it may make some sense for us to ask hard questions about whether or not people should be able to be returned to prison, at least for the full length of supervision. The challenge is what you brought up, and that is that I am not persuaded that there is a clean division between crimeless revocation and crime-filled, crime-full. I don't know what you want to call it, right? What you want to call it?
Crimey.
Revocation, right?
I like crimey revocation.
Crimey, I like that. I like it. I'm going to use it. A revocation premised on commission of a new crime. And there are lots of reasons for that, including some you alluded to. A number of years back in 2016, I did a study that examined a sampling of revocation cases in Wisconsin, for example, from 3 different regions of the state. And I just looked at a 3-month sample of every single revocation action that was filed in a variety of different supervision units. So I got some of everything from all over the state and was really struck by a number of things, but one of them was the degree to which whether or not something is a revocation premised on crime or is a crimeless revocation has nothing to do with the behavior in many cases, at least the behavior of the person on supervision. It has everything to do with the behavior of the district attorney. Yeah. Right? Because in some counties, if someone has a drug-related offense, it's getting charged as a new crime, a possession crime usually. In other places, it's not being charged at all, right? It's being treated as a situation where someone has a substance use disorder and needs treatment intervention of some variety. They're going to receive often just a light sanction from the agent. If it does progress to revocation, it's usually because it's happened many, many, many times previously, but it's still not charged out. In other jurisdictions, the first time someone has a dirty UA or other evidence, indication, reports that they have been using drugs, it can result in new criminal charges being filed. So these are identical circumstances. In some cases, actually, the one in which the crime is charged is less serious than one in which it's not. One is the less serious is sometimes going to be called the crime-based revocation, and the more serious is sometimes going to be called crimeless. That doesn't seem to be capturing something meaningful to me. The same is actually true. An example I saw a lot was actually in situations involving battery. So domestic disputes in particular, whether it's with a romantic partner or with a roommate or a sibling, people get into a fight, there's a disturbance, police are called in some way. In some jurisdictions, that's going to get charged out as a disorderly conduct at least. Perhaps it's going to go all the way up to a battery offense if someone's actually hit or hurt in that situation. In other cases, the sibling, the roommate says, I just want to just tell him to go away for the night. I don't want to deal with this right now. There's no arrest made. There's no charges issued. And so it gets treated as crimeless, right? You were just being disorderly, but it didn't lead to new crime. In both cases, again, same behavior, different results that have nothing to do with the person. Yeah. And so I think it's dangerous for us to put too much stock into that particular distinction. Instead, what it seems to me makes more sense is for people interested in system reform to focus more on the behaviors that are actually at issue, right? What kind of behaviors do we think legitimately should result in someone going back to prison? That's a hard question that I find often folks who want to improve the system don't actually want to answer. Right? We're happy to point to all the times we think someone shouldn't go back, but we don't actually want to engage too deeply in when actually has there been a significant enough breach of the conditions of supervision that we don't feel like it's a good idea for someone to be in the community. Ever? Sometimes? When? Because I think once you answer that question, it becomes much easier to think about how we structure laws to ensure that it's only those cases when someone goes back. Just to throw one more complication in, absconding is a big one. Right? So there have been a couple of folks in the policy world who acknowledge that absconding is its own kind of special category. Right? So missing a meeting can just be a calendaring error. But when someone on supervision just stops playing, right? Like, nope, I'm not going to show up. I'm not going to come. I'm not going to do anything. I'm not going to answer my phone. Like, no. Basically, the opt out of their sentence. Like, what does the system do? It's not a new crime, so you could call it a crimeless revocation if that happens. But it seems to me that that's a fundamental attack on the legitimacy of the sanction. And if we want courts to acknowledge that community supervision is a legitimate sentencing option, if you think it should be, right? And I think of this more in terms of probation maybe than extended supervision even. If you want judges to think about sentences that aren't behind bars, we have to have a way of enforcing those sentences and giving them some kind of meaning, which suggests you shouldn't be able to opt out. Now the question is, though, what do you do when someone opts out? Like, what should the sanction be? I think it's a hard question, but it's one we need to be able to answer. And I think reformers need to not just naysay and say all the things that are wrong, but have a vision for what robust public safety looks like when it comes to law, and particularly the area of community supervision.
I think something that stands out for me that I struggle with is I've lived a charmed life post-incarceration, right? Because I came out with a soft landing. I had a place to go. I was in graduate school. I didn't really need a job, but I had something through my school, a fellowship that paid like 20 hours a week, $15 an hour, $15.86, I think, to be exact. Who's counting? And most people don't get out with the same level of supports and things that I did, right? Now, I don't know what most means, but I just know a fair amount of people struggle when they come home with those things that I had in place. So I'm not a success story. I tell people that commonly. Don't look at me as an example of what you can do, or look at me as an example of what people need more so, right? To then be able to have what kind of has been for me. And there's nuance in that as well. Like I'm also different in different ways. So it's not that simple. But I always want to be very cautious to think my experience can then be extrapolated to what we should be focusing on. And in that, there are folks who genuinely have a bad experience with their agent have a bad agent. I just think those are really outlier scenarios, right? When I deal with the head of probation and parole from Milwaukee County, when I deal with agents here, when I get to know these people, I'm like, yeah, you don't have the time to be giving people problems, right? Like, so if something's going on, it's likely there's something else in the story that I'm getting from this individual about, hey, as I do consistently, my agent is this or that, I'm having trouble here, what do I do? Right away, my question is, what else are you doing that you're not telling me right now? Because from when I was inside, consistently, people would come back and they would pitch this case of, I got locked back up just because I missed my appointment. And you look at their paperwork, it's like, oh, and you cussed 6 people out, and you were carrying a gun one time and they let that go. Like all these other things that built up, that this was the straw that broke the camel's back. That's not what you got revoked for. Technically on paper, maybe, but there were all these things. So like on one hand, systems should not be letting these things happen and then doing something. It should be like swift and certain, right away, weekend in jail, a week in jail next time, right? Maybe that's one thing we for sure should be doing. But like there's this illusion of this is the small thing that happened and we don't tell the full story. And so when I talk to people that are trying to help folks a lot, and I say right away, actually, I don't think it's nearly as bad on paper as people are making it out to be. I know a very large number of folks right now that are doing illegal things that aren't getting sent back, and their agents are letting them working with them through these, right? And I'm like, you don't get those stories, but you get the loud ones of the person who doesn't want to tell you the full extent of it. But I just don't want to always ignore and kind of disregard the very legitimate complaints sometimes that do happen about a person not getting a fair shot for some life unfortunate example or event that they shouldn't have gotten revoked back for. So it's just like I'm always trying to balance that, my experience, what I see, what I know, versus the times when, yeah, there are some really crap scenarios that people just didn't get a fair shot within that. So like that's my personal concern that I always deal with when I face this exact same issue, when I'm facing my colleagues and humanizers saying we gotta address crimeless revocation. I don't want to full scale be like, that's kind of a stupid issue. Let's look over here, because there are some legitimate stories in there that need to be addressed. And so I just always think to myself, like, how do I navigate what I know, what I'm hearing with the legitimate gripes that sometimes, not gripes, but injustices that happen.
Yeah, I think injustice is a point, and
Yeah.
I certainly don't mean to suggest that there aren't.
And I never meant you did. Yeah,
where,
never said yeah.
Where there's not a crime and there isn't a problem. I mean, again, what we have to just always remember is these are systems composed of human beings.
Yeah.
Human beings being supervised, human beings doing the supervising,
Yeah.
human beings doing the supervising who are themselves being supervised. I mean, this is a dynamic that I think gets ignored a lot. And when I spent a number of years doing interviews around the country with supervision agents.
Yeah.
And it was always fascinating to me because I would talk to the agency heads and then I would talk to the people doing line level supervision. And so often, like the way probation officers talked about their bosses was the way the people under supervision talked about their probation officers. They don't understand me. They don't know what pressures I'm under. They don't. You're like, I feel like I heard this already, right? And because there is that cultural pressure that, like, I think trickles down. Right?
Yeah.
When you have a culture where people are feeling affirmed and professionalized at the agent level, they tend to be more magnanimous and like holistic in the way they supervise because they are having that modeled and it's part of how they are being formed in their professional identities. And when you have this feeling that like any mistake is going to be a political nightmare for all of us, make sure your paperwork is done all perfectly and the paperwork is what matters. You lose the human element and you lose it at every level, right? And I think that that is always true. And so there certainly are going to be examples of line level agents who often themselves, not always, but they can be young. Sometimes some have more educational background and life experience than others do, right? Certainly people can be petty when they're given power to wield over others, right? That unfortunately is how human beings can be. And also, you're right, that often they're dealing with bureaucratic pressures, they're dealing with all kinds of other dynamics that mean they're not looking for more work. And revocations are work. They take time in addition to directly affecting real human beings' lives, right? And so I think you're right that we always want to know, like, what is the story? How does it work? And often behind a revocation is a very long supervision history of other kinds of issues and problems that have developed both behaviorally and sometimes in the relationship between agent and person under supervision, that's often at play.
Yeah. One line that I sometimes worry if the DOC hears me say it, they won't like, but I think it accurately encompasses the structure of the way corrections operates is it's not about corrections, it's largely one large ass covering operation where everybody just doesn't want to get in trouble for something, where they know what the decision should probably be made here, but they don't want to be the one to make it in some cases. Not everyone, but I just see that commonly where, again, I would like to work with you on this, but I don't want to get in trouble by the person that's supervising me. So I'm just doing what I have to do and working on my paperwork to make sure that that part, my self-preservation of my job, is in place. Which is unfortunate, but that is structurally how everyone's under those pressures. And it's really interesting what she commented on about they're complaining about the same thing.
Well, and corrections, I think, is uniquely vulnerable to this because the history of American politics so often involves the fall of politicians based on some random one-off criminal justice situation gone awry, right? So frequently, even agency heads, right, are subject to higher authorities whose political careers may turn on not having something blow up in the headlines about corrections or criminal justice. And as a result, we frequently have a very risk-averse culture in corrections, which is really unfortunate because it's a place where great good can be done, but it's not going to be done risk-free. Right? There will always people make bad decisions, whether they're in the criminal system
it's a risk
or
either
not.
way.
Human beings do stupid things, right? And when human beings have lots of vulnerabilities and challenges, like the odds that something's going to go wrong are slightly higher than they otherwise would be, right? In the general population, for sure. You're dealing with a higher risk population. And so there can be bigger payoffs and there can be downsides as well that you want to be attentive to. But too much risk aversion means we have a system that starts creating the harms we're trying to prevent. And I think our problem is that now we have a system that often creating as much or more harm than it's resolving.
Yeah, and that's the interesting part about the risk aversion is that we frame it in a way of we're just trying to avoid the riskier decision, but either way it's a risk. And right now we have taken the safer option that is actually resulting in less safety in a lot of cases and an overall system that is not making things better for people. And so we're just not seeing the fact that we're also taking a risk in the decision we've made, but we're not connecting that long term and the things that are going on in the macro with right now these risk averse decisions. So that's what I think is it's not framed in a way that people would know in the immediate when the decision's made that they're also just as much taking a risk.
Absolutely, there is a risk, but it's a more hidden one. It's slower to materialize, and so it's not going to come back and bite the person who made it right as quickly. But it will affect people and their lives and our community's safety, and it matters just as much.
It's somebody else's risk. This is a risk that I can take that the next dude can do with 20 years. Yeah, exactly. Right. So the last question I asked about crimeless revocation before we have the last topic is why, and I've always wondered this, why is crimeless revocation data not included in the recidivism data in Wisconsin?
So I don't know what DOC's response to this would be. They probably have a much more official answer than I do. I think in general it's this problem of definition. What is crimeless revocation? How are we defining it? What does it mean? There is not one uniformly agreed upon definition. For example, do you include absconding? Do you not include absconding? Do you include behavior that could have been charged as a crime but wasn't? I mean, that's almost all behavior. Not all, but close, right? Do you include cases where there was a crime but it was dismissed? I mean, I can think of all sorts of different definitional questions we might have. And because resolving those would change significantly the data you collect. Plus, it's just hard to get all of this really granular data. We don't, as I'm sure you know, because you've been working this long enough, and most of your listeners probably know this too, we don't collect great data on crime. And when it comes to the specifics of what are factual allegations, my goodness, I think that, half the time, by the time someone's pleading in court, we still don't actually have any idea what happened, right? Much less being able to go back and like look at this question of what led to a revocation. It's hard work to collect it. There's no standardized way of coding it or entering it into some database. Usually you're talking about having to go review paper files and make judgment calls about which alleged violations are actually linked to the revocation. So there's no easy way to gather this data up.
Okay. And that's, like you said, that's a very important point about a lot of this is the data is significantly lacking. And I think I've been shocked. I think a lot of us, as we get into this space, like you early on, probably in the beginning stages, were, I would imagine, shocked that some of the stuff wasn't being tracked or wasn't known. And so a lot of us, we just assume it's out there. And usually get in, you're like, oh, so you're all just really flying blind. And a lot of this, huh?
Yeah. 100%. And I think that's true of criminal justice in general, right? I'm thinking of one state I observed where felony sentencings don't always involve collecting criminal history data. So people are being put on probation when no one knows what their criminal history is.
Yeah.
And I'm like, huh. And not surprisingly, that state had a very big scandal and a blow up. And you're like, I wonder, that seems so predictable, right? But they were like, well, we just don't have a system for gathering that data before the time of sentencing, which surprised me because that's not how most states operate.
Yeah.
But there are all kinds of ways where we just have these big information gaps in our decision making. And quite frankly, even when we have data, one thing that's really important for people to understand is that it's just often not high quality. And that's, quite frankly, that's true in a lot more areas than we would think in the world, kind of to a concerning degree. But when I was doing field observations, for example, watching probation officer interactions with people on supervision, I would go out and spend time in the field. I would come back. I would have my own little field notes that sort of captured what had happened. And then I would go back into the official system and notes, like let's say a week or a month later, to see what the agent had written and sort of compare the two. There were big differences between my field notes and what got captured. Not on purpose. I think part of it is just memory degrades really fast, and people often don't have time to write stuff down. Like if you're out in the field visiting with people all day, it might be a day or two before you have time to sit down and recount that. You're missing information. So I often had many, many more violations in my notes than actually ever got recorded, for example. Sometimes information would get inverted or mistaken. Right? I think that we have to remember that even official data are subject to lots of error. Anyone who's ever read their medical chart or medical records knows this, right? The doctor's notes are riddled with errors, some of which are important. And I think that it's really good for us to be wanting and demanding better information in a system that affects so many people's lives and that involves so much public investment. And at the same time, I think we need to remember that numbers are never going to capture the fullness of human reality. And so that's why the work you're doing with people's stories, I think, is so important as well, because it captures really important aspects of this work that aren't captured by numbers.
Yeah. So I want to take a step back for the last question and look at the in-prison portion of the experience. So you highlighted something at, I think, the judges conference that I've looked at and always was really hyper aware of and wanted to kind of talk to about more. But you had a much more, let's say, official and I guess provable argument or case to be made, whereas mine was just like my solo experience. I think it was really helpful because I'm just kind of giving what I've seen in my observations, but you had more of some data you could provide and some studies that you maybe could highlight as an example of things. And so what that topic is around how people don't realize the very culture and the very qualities that we are fostering for people in prison are the very things that are going to set them up for failure when they get out. And the very things that people need when they get out, we're weakening and diluting or destroying for people inside, which is agency, individuality, which is empowerment. And so just curious if you can speak about what you've seen or what your, like the case you kind of make sometimes when you talk about this.
So I'm sure whatever I said last time was so eloquent. I don't know. I won't be able to replicate it here for sure. but I'll kind of talk and hopefully we'll go in the right direction. So I think you're right. When you think about what helps someone succeed in prison, it is largely going to be disappearing, right? The less a person is noticed, the less likely he or she is to be interfered with, and that's going to be true both by other prisoners and by staff. Because in jurisdictions that have any means of reducing people's time behind bars, whether that's parole or sentence adjustment or any good time, any of those things often can be taken away or interfered with by disciplinary reports, right? Tickets. So when people are in prison, just like in the community, right, on supervision, there are rules that they have to follow. Failure to follow those rules can get you sanctioned, and those sanctions can be anything from something very small, right, loss of some TV privileges, to things very significant, like being placed in solitary confinement for a period of time, losing access to work opportunities, treatment opportunities, things of that nature. And having significant disciplinary infractions, and significant in the prison context is often not what we would think of as significant in the outside world, right? Anything disruptive can mean that judges are going to see you as someone who is non-compliant, doesn't respect authority, and is going to be a risk in the community, right? Thereby denying you opportunities for release, even opportunities to move to less secure security settings, right? So transfers from, let's say, a maximum security to a medium security prison, not going to happen if you're getting lots of disciplinary violations. So what you want to do to avoid all of that in prison is, again, to just not do anything. The less you do, the better things will be. Obey everything, be passive and responsive rather than proactive. Because the kinds of things in prison that can get you in trouble. I remember I had some students who were representing a guy who got tickets for taking extra ketchup packets at dinner, right? That got him a ticket. Things of this nature, right? Like very, very, very small acts of disobedience or desiring something, wanting something can get you in a lot of trouble. That means passivity is the key to success. The problem, of course, is that when you get out of prison, passivity is the worst possible attribute you can have. Because the reality is, you know much better than I do, is that life after imprisonment is really hard. People get shot down a lot. Right? It is hard to find a job. It is hard to find housing. People are going to treat you differently and poorly as a result of you having been incarcerated. You're going to get rejected a lot, and in order to succeed and get what you need, you're going to have to keep trying new ways of getting the things that you need, right? You're gonna have to be persistent, you're gonna have to be vocal, you're gonna have to self-advocate, do all of the things that in prison get you in trouble, right? Because in prison, frequently, any kind of conflict with staff, right? Talking back to them, even asking questions, right? If it's seen as an attack on their authority, even in small ways, can get you in really big trouble. So again, not doing those things is rewarded in prison. On the outside, it is linked with failure. One of the most interesting findings of the work of Shad Maruna, who's a sociologist who's done really impressive work about desistance, people's patterns of extricating themselves from crime, disentangling themselves from criminal involvement. His most interesting finding is that the people who did best upon release were those who had the least realistic sense of what it was going to be like for them when they got out. So when he was interviewing folks, those who were most realistic about just how horrible it was going to be, it was so depressing, they just did very badly on the outside. And those who were like, I'm going to win, all the winning, right? And you're like, statistically, that's not very likely. Like, they did better. And it was that persistence against odds that actually predicted success. The more realistic people were, kind of like the less well they did. which is a little counterintuitive. Usually you think you want to kind of live in a true space.
Yeah. They created the reality, it kind of sounds like.
But I think that is part of it, right?
Yeah.
Is that you can also, I think you can hold both things at once and succeed. But if you give in to the fact that the odds are against you, that passivity, that sort of desperation, you do poorly. Yeah. And so in some ways it's kind of weird that we let things like disciplinary violations serve as a proxy for how well you're going to do on the outside, right? Now, of course, if you're in prison and you're punching everyone in the face, this does not seem to me to bode well for life on the outside, right? We have not learned conflict resolution skills. But if really what you're doing is asking a guard who's doing something that's like really not legitimate, why he's doing something not legitimate, I don't know. It seems to me I might want that guy on my team on the outside, right? Yeah. But again, we often don't ask those real deeper questions about what is happening and why is it happening. I will always remember I once represented a gentleman in an appellate case, and we had a tough. It was a tough legal position we were taking. It had never succeeded anywhere in any court, so our prospects weren't great. But we were talking about success and what that would look like, and he was going to be released from prison soon. And we had a long talk about supervision and sort of how to make supervision successful. And I observed then, as I had actually observed a few weeks earlier when I had done an oral argument in front of the appellate court, that the temperament of my client and the temperament of the judge one of the judges I was appearing in front of, were remarkably similar. They were both extremely combative, bright men who did not restrain themselves from saying exactly what they thought. And I thought, y'all are awfully similar. Concepts. The problem is everyone's going to say, yes, Your Honor, to one. And the other guy's probation officer is not going to like him very much, right? Unless he tiles it down. And so that awareness of like the things that help people succeed can also become problems in the system.
Transferable qualities.
And I think we need to interrogate that more and stop acting like people's self-advocacy is necessarily a bad sign, while at the same time, of course, being sensible and recognizing that there are certainly behaviors that can manifest in and out of prison that are problematic and that kind of invite our intervention.
Wonderful, I love it. So last question I have for you, summary of everything we've talked about, of your views. We get this question kind of sometimes, I get it in variable in different ways. Why is Wisconsin's system the way it is? Like, is there any reason specific to this state as to why we have our TIS and we have the, and this is super broad, so feel free to punt on this.
Indeed it is.
But why we have the highest incarceration rate for Black males and I think Native Americans in the country. And so why is it specifically in these ways very not good, I guess, in Wisconsin versus other states?
It's a good question, as you said. It's broad, and I do think that the answer to each of those little sub-questions you asked is a different answer. To the first, why are we so different, like on truth in sentencing? I would say, I don't know that we are, right? Are we a more extreme version? Yes, but let's face it, only marginally so, right? Truth in sentencing says that judges should be handling sentencing decisions, not parole boards. That might be okay if you had judges who didn't feel constrained by politics or other factors to impose really long sentences, right? I think most of our problems in criminal justice aren't about our actual sentencing structures. It's about our sense of proportionality, right? Americans, you've heard me say this before, right? We like to supersize things. We supersize our Big Macs, and we like to supersize punishment. Like more is better. And of course, that's not true for human beings. More is not always better. And whatever structure we have, if our attitude is more punishment is better than less punishment, we're always going to be doing things that are damaging to people. And I think that we do that nationally. There are some ways Wisconsin does this worse. There are some ways Wisconsin doesn't. So if you, right before we started recording, I was showing you a chart that was comparing all kinds of punishment, jail, prison, probation, parole, across all the states and sort of adding them all up to get a sense of the size of correctional populations. Wisconsin is right in the middle, which is where we always fall, right? So relative to other states, we're kind of right in the middle of the mix. But of course, the United States in general is much, much more punitive than other comparable nations, right? So we have a proportionality problem. When it comes to disparities, I mean, that's its own much bigger problem and question. It's certainly rooted in history and in segregation, right? We often think of the American South as like the seat of segregation, right? Because you can point to, I mean, I remember my mother telling me about growing up with separate drinking fountains. She grew up in New Orleans. But in the North, there is just as much or more segregation. It's just more hidden, right? Because historically we've had smaller percentages of the overall population who are people of color. It hasn't been as visible a divide as in the South. The thing about the South is integration is also much easier in some ways because of the size of populations. It's easier to get political power. It's easier to have people of color in all levels of authority and kinds of authority when there are more people to hold those positions, right, as professionals, across, and not just in government, but as teachers and doctors and all of the things that help people build wealth, build influence in our community. In communities where you have a much smaller population of people of color, it's harder to break into those roles often. But it's bigger than that, right? Your own city, of course, Milwaukee has a very long and complex history around segregation and disenfranchisement in various ways. For our Native communities, of course, that also each has its own sort of story of isolation and segregation in Wisconsin. And it is unfortunately true that there is a big global pattern, right, across history, across space, of othering folks, right, and using incarceration as one tool in that othering process. That's direct discrimination. And then, of course, on top of that, we can layer all the kinds of indirect discrimination that happen when people are disadvantaged, right? If you have options, often crime isn't as attractive or necessary because you got other stuff going on. And unfortunately, when we have people dealing with compounded disadvantage, as is especially true here in Milwaukee, when people don't have options, things get pretty desperate pretty quickly. And lots of other layers too, right? I don't want to offer, I feel like I'm getting too quippy, because we only have a little bit of time on a topic that deserves a lot of actual, intense engagement, right? Because I don't want to give, we've talked earlier, right? I don't like having these superficial little soundbite views of things. Right? It's complicated. Why we have the racial disparities in incarceration that we do. I do think it's important for us, though, not to just be like, it's complicated, and then never talk about it again, right? But rather to dig into those reasons and to continue to create opportunities for folks to flourish, right? In every possible way in Wisconsin.
And I appreciate you sticking to your guns about it's complicated, it's nuanced, right? Because that's I think we get away from that too much. And so it is really, that's why I'm hoping that especially this conversation will help folks understand that you get some of these slogans and you get some of these quips, but then also that is just a bit of a teaser about just consider that not the truth. Consider that the teaser and then look into it a bit more. And, there are ways I think we can almost have a bridge of a middle ground of what's the next stage of not a whole study you have to read, but maybe just 2 paragraphs that kind of get, we should have different layers so that people that are very busy can get a better sense of things. Not maybe the whole story they don't have to have, but also not just the quip. What's that in between?
I mean, anytime something has become institutionalized, right, and law is one way of institutionalizing a practice, there's a reason that it happened. Often there are lots of reasons why it happened, right? There were concerns. This seemed a solution that was available. There's a reason why people liked this option rather than other options. And I think understanding that helps us then think about, if you don't like it anymore, what are the alternatives and how are you going to address the underlying problem that led to it being adopted? Because if you don't have a meaningful alternative that addresses the problem that led to the law being adopted in the first place, your solution's not going to last. And I think that reformers would do really well to not just be soundbitey or just not getting rid of stuff, but thinking about what are we going to replace what we have with that's meaningful and protects our communities and our kids and our families and helps people really, flourish.
Yeah. A quote that I brought up commonly in this space that kind of, this is my version of a quip, like response almost, is don't tear a fence down unless you know why it was put up. And I think like that's why we have to talk to, like sometimes I think we think, why are we talking to the system about the solution? Like they're the ones that run the problem. But also they know why certain elements are in place, right? And sometimes you get in these rooms and you're like, oh, that actually makes a lot of sense why that decision was made. I may not still agree with it, but it creates a whole different way that I look at how we then come away with the solution instead of just complaining. Because it's like, this also has to be dealt with. I was not aware of this. I was just looking at this part of it.
Totally.
Yeah, so it is
so
interesting.
many unintended consequences. And so many times it may be that when you understand the reason, you can show easily enough that that problem doesn't exist anymore, or that there's a better way to solve it.
Yeah.
And then I think we have much more fruitful, bipartisan, successful interventions.
Yeah. And I was just talking to yesterday with our guest yesterday about collaboration. You also get a lot more grace for people who made decisions you disagree with when you start to look at all the things they were faced with to make these decisions.
Totally. This is an imperfect world.
Because it is definitely not easy. Yeah. Last thing, do you have any questions for me?
Yeah.
I know I didn't like.
No, but I love it.
Yeah.
So I'm trying to generalize from what my normal question to you is, which is, what can I do to help? What can people who are, first of all, let's do scholars. What can scholars do to be useful, and teachers?
I think the two things that stand out for me are, one, I would love to have a way for there to be more interaction between those of us that are like in the practitioner world, I guess, if that's fair to say.
Yeah.
With access to folks that are seeing some of that zoom out, right? To kind of say, hey, yeah, that's cool, that's great, right? But like, consider this before you run across the street. Because once you get too far, you might ruin a lot of things that you're not gonna get a second chance at. And you need this first before you let me make sure your water bottle's full all the way before you start this hike. Like, I think there would be that element to any time we're going off on the things that I would love to see happen. And the other part of it is that I think talking to each other, I feel like there's also, I think Wisconsin's been pretty good. Like Wisconsin with Mike Koenigs and with Dan Gruppe, they have kind of created this like communication vehicle where they're aware of each other a bit. You've got Ted Lentz at UWM. You've got Darren Wheelock here at Marquette. I think that MSOE might be getting a bit more involved. Mike Carrier does some like sideline type of academic work with it. But I would love to see, and I've kind of talked to each group about a bit more of a listserv or some way to all be aware of what's going on. And then even sharing things that are happening across the country, like all of that. Like, I love the listservs I'm on for different things. I'm on a pretrial listserv. I'm on a formerly incarcerated college graduates network listserv. We've kind of created one for our collaborative here. And that allows for people to just, at their own pace, be aware of what's coming out, right? And so like those are things I think would be really helpful to help the collective of scholars be more aware of what they're doing, and then the practitioners be able to have a little more access to say, hey, before I go jump off on this, can you look at this real quick? Like that I think is so important. Because then you end up having to have these consistent conversations or questions asked to you. We're like, no, that's not what the data says, because we aren't really aware of it before we jump out into these things. So those would be my comments. Again, just having been asked that. Maybe next week I might have another thing I would add to it. Yeah.
Good
cool.
Deal. Thank you so much.
Yes, thank you, as always. This was the longest episode we've ever had, but it was incredibly informative, so I don't think anyone who's gotten to this point will feel it was a waste of time. Nevertheless, I'm going to make this the shortest outro I've ever done to possibly balance it out some. I'm massively grateful to Cecelia for taking the time to make the trip over here when she didn't realize until the day before that it was in person. And she has a very large family to navigate her schedule around as well. Other than the excellent commentary and explanations of the criminal legal system in Wisconsin, my overall takes from this interview are: one, if you didn't already know, the system is utterly absurd in the way it operates in the name of justice in Wisconsin. But Wisconsin is both better and worse than probably any other state in some capacity. It's the American approach to justice overall that is absurd, which is preaching to the choir for almost anyone connected to this work or who has experience in the system, whether directly or indirectly. But even though a person may have that experience, it doesn't mean they fully understand what's going on, how things came to be, and the nuance of how we should best approach the situation to change things, especially when it comes to applying the data. As we talked about during the interview, I strongly encourage anyone that is looking to start any program, organization, or effort in criminal legal system work to really dive into the reports, the studies, the commentary, and insights from those who've been doing this work before hitting the gas pedal. A well-intentioned person can cause more harm than people who don't try to help at all, even sometimes those who actively oppose. To use a Buddhist parable I love, oftentimes in life we feel and tell others, don't just sit there, do something. But sometimes it's the opposite. Don't just do something, sit there, inquire, learn, then move. Thank you for listening. Peace.